kina bagina turanga kina marama vikim ne oni borong tu mai kina ngauna borota kina Vakekeli. Na urongo diana salini kakambura kina radio Fijuan sarabi talangan FBC TV. Kanda kinda bagati una nonta bulangi. Ene kabinda ina turanga minister punilaw nonta matentu Prime Minister Watawa. O Mr. Khaiyum nonta bulangi tiko Aiyaz Saiyed Khaiyum. Nonta bulangi. Kana mai vosa tiko pamadala tiko. Ena kami baleta ni labi ni nonta abuni wabulwa. Sena draft constitution. Buluvinaka Mr. Minister, for the listeners on Radio Fiji One on the Vakekeli program.
Well, thank you for having us.
And maybe you can start off this program with, I know you just came back from the trips around Fiji. You were in Vanuatu and also in the West. How about the feedback from the people during those meetings, during the discussion for the draft constitution?
Sure, thank you for that. But before I start off, I'd like to also give our condolences to the people of Madhuwata with the passing of Tui Madhuwata, and of course to his family. We have, as you know, the last trip last time we were in was in Savu. Before that we were in Tavyuni, and before that we were in Duvu, in Anronga, in Ba, in Lotoka, and of course in Suva. And we had some small meetings in the Mamanuthas. And this morning we were invited by the Fiji Employees Federation. The response has actually been very, very positive in the sense, I don't necessarily just mean because people are simply endorsing it, but the response has been good that people have been asking questions and their willingness to actually know the reason why behind some of the provisions have been put in. Why, for example, you have socio-economic rights, why is there, for example, 45 seats as opposed to, say, 60 seats? Is there protection, for example, for Itauke land? What do you mean by secular state? What is the implication of, for example, having the Accountability and Transparency Commission, which is, in fact, a lot of people are very, very positive about that. I think a lot of people seem to be very positive about the fact that this draft constitution has a lot of accountability built into it for those people who hold public office. If you're Prime Minister, President, Permanent Secretary, Ministers, you have to now, under the draft constitution, once it's formulated, there's a lot of accountability. And so freedom of information is what they're also quite happy about. So it's been very positive in that sense. A lot of people, for example, when they, at the beginning of these presentations, when they come in, you can see that they're perhaps a bit apprehensive, but as we explain and go through each of the sections, they seem to be very positive about it.
Vikimne na kanda vikimne na boro ngoti mai na Radio Fijuan na kabinde na ngono boro takina Vakekeli na ndolo taleti wana telefoni kana ra ni ngir mai kina namba ni telefoni na toluroro sai vadio na rau toluroro sai vadio sai bandua na vitu toluroro dio na rau kina vitu toluroro dio sai bandua vikimne na judicial ke vai tiko na nomuni vota taro membaleta na lave ni nonda buni bobulon sina draft constitution kana bobulon ni tiko saranga na turana buni lao ni nonda matintu Mr.Aiyaz Saiyed Khaiyum and rani na soma na nomuni bota taro ke ni taro nga mai na vosa voi tauki and ngai tole me na bonde tegiwa se ni vosa nga me na vosa pertania and na nomuni taro kana rani na vingomitiko and nonda ngonongo and e kai vindai Mr. Khaiyum, people have been maybe they have been talking about land issues. Maybe you'd like to reconfirm to them, especially to the Itauke listeners on Radio Fiji One.
Sure. I think, to put into perspective, for example, today now, 91% of all the land in Fiji is Itauke land. So it's about 9% of the land in Fiji is freehold or crown land. 91% of the land is Itauke land. The sort of protections, supposed protections that were put in place in the previous constitution was they had what they call the entrenched provisions. So the Native Lands Act, the Native Lands Trust Act, the Rotuman Act, the Banaban Act, the ALTA, those sorts of provisions were put in and called entrenched provisions. In other words, you could not change any of the laws. Even if you wanted to change a full stop, you could not do it unless you had 2/3 of the House of Reps approving it and you had 2/3 of the Senate approving it. And those Senate members included the GCC nominated members. In this draft constitution, you will see that there are 2 ways, in fact 3 ways, in which we have protected Itauke land. And indeed, for example, freehold land for that matter too. where we have included under Section 26.3, you have unfair discrimination. And for the first time, we've in fact included culture as a particular provision in the Bill of Rights. Now, culture, as you know, is very much linked to land for Itaukei people. Land equates to culture, and culture indeed includes land also. So if there is any discrimination on the basis of culture, or land for that matter, you can say that there is an infringement of your cultural rights. That's number one. Number two is that there is also provision regarding the expropriation of land. You cannot expropriate, in other words, take away anybody's land without their consent. Now, on top of that, you have these rights are included in the Bill of Rights. Now, the Bill of Rights says that any law, not just any law, but any executive decision, any administrative decision that's made by a government, or even, for example, a DO in some outpost, making any day-to-day decision, must always adhere to the Bill of Rights. So even, for example, a cabinet decision must not in any way infringe upon those rights. Now, to demonstrate to you what happened, in 2006, as we've been talking about the land issue in Momi, in 2006, the former cabinet, the then cabinet, essentially allowed for Itaukei land to be converted to freehold land. The Native Lands Act, Section 5 says, as that time it said, as today it says, you cannot permanently alienate Itaukei land to freehold land. In other words, see, once you convert Itaukei land to freehold, it's gone. You can't get it back. The only way you can get it back is if you buy it back. So what actually happened in 2006, that even though the 1997 Constitution said that you have these entrenched provisions, and the idea of the entrenched provision was that this law will ensure that Itaukei land won't be converted to freehold land, the then cabinet still did it. Now, by having these protections built into the Bill of Rights, no government decision, no cabinet decision, no administrative decision, no parliamentary decision can in fact take place if it's going to breach the Bill of Rights. So that gives even additional more protection. Now, the other issue, of course, is that in order to amend the Constitution, you need to have 3/4, not just of Parliament, but 3/4 of the voters to actually agree with any amendment. So you have an additional protection on top of that. Under the previous Constitution, you had 2/3. This is 3/4, which is a higher ratio. So even if you wanted to, for example, amend the Constitution and propose a bill to in fact undermine the Bill of Rights, that could even be challenged in itself. So that is a protection that's been given. And given the fact that previously you had entrenched provision that was supposed to provide protection, it did not. We are currently, for example, looking at some other areas that in the 90s or so, that some Itaukei land was also converted to freehold land. And we're carrying out some investigations in respect of that. See, I think we have to understand the philosophy behind the ownership of Itaukei land. The philosophy behind it is that it's been passed on by the ancestors. And the people who own the land in a communal form are in fact holding it in trust for the future generations. And that philosophy is enshrined in the Bill of Rights vis-a-vis those two provisions that I've just highlighted to you. And in fact, in the many discussions we've had throughout the countryside, when people have asked this, we've explained it to them, we've demonstrated what happened in the past, and they seem to be very happy about that.
Vi kim ni nakanda ni warongo ti mai ta sarongo ti kan bi wande tanki mai wana turana buni lao en buni vi kai tu en labi ni buni wabuli wa na tango makitu wavinak na ngele me bakau ni sarongo ti ona kini pamadal en ndo manda na nonda dingo ngala kan ngauno boru takina Vakekeli sana roni na ngai dingo mitiko na no muningi. Ni sambulu vina vekim ne nakanda ni borongo ti mai kin radio fijuan do mo vitina bonga ni vina vekim ne ni warongo tiu mai kasaraba tiku mai en FBC TV na ngauna waru taki na Vakekeli dono e kanda sa tongo na taliwani ni sambula kimni au krene adamuni pa take na unoni ngiri makina kina nomni taro
na wale virtuale seo minasinga ya nailuwa Mr. The Honorable the Attorney General, Acting Prime Minister, I've just got a concern on Section 91(2) and also on Section 105. But first, Section 91(2), where the Prime Minister is the Commander-in-Chief of the Republic of the Fiji Military Forces. I have no thing about the present Prime Minister, but my worry is if it goes to somebody else who hasn't got any army background and he uses his power like they use in the African states and the Asian states, where they take the government and hold it for so many years. That is my worry on that. If somebody else is a prime minister and uses that power unwillingly. And the second one, sir, on Section 105, subsection 1 and subsection 3. Subsection 2, sir, is quite all right, except that if we delete following consultation by it with the Attorney General, I think the appointment of judges and the judges should be neutral to bring in the Prime Minister and the Attorney General. Because of the political affiliation, it would be a little bit unfair to look at it that way, sir. Thank you very much. I'll wait for your comments, sir. Thank you.
Thank you for those questions. They're very, very pertinent questions. In fact, the question, in fact, in respect of the Commander-in-Chief has been asked also. Let me explain the rationale behind it. Given Fiji's history, the rationale has been that, given that we've had the coups in the past, we had two coups in 1987, in May and September of 87. And then we had an attempted one in 2000, and then, of course, the events of 5 December 06. The rationale is that to draw a closer relationship between the RFMF and the elected head of government, which is the Prime Minister. This is a rationale to draw that relationship. In respect of, as you would know, I think the caller, the gentleman, maybe of somebody of military background, would also know that the Commander-in-Chief is more of a ceremonial role than anything else. The person who leads the RFMF is the commander. The Commander-in-Chief is more of a ceremonial role. However, despite that, the idea is to draw the relationship between the elected head of government and the Commander-in-Chief of the RFMF. And, of course, the RFMF itself. So, we can get over, people talk about the coup culture and creating a sense of removing that coup culture and drawing a relationship between the elected government, which is elected by the people of Fiji, and the RFMF. In respect of whether those powers will be abused in the future, because this constitution has been drafted for it to be in place for decades, the idea is that you have various accountability provisions that have been built into this constitution. For example, you have the Commission of Accountability and Transparency, which has numerous powers to investigate the President, the Prime Minister, ministers, permanent secretaries, and other public office holders. So they will always have to ensure that they toe the line. And the Commission has the powers to, in fact, go in, in fact, refer them even to, various prosecutorial type of agencies. So those checks and balances are also kept. We've also got the Commission on the Human Rights Commission, Anti-Discrimination Commission, where people can feel if they have any form of grievance vis-a-vis this position, they can go and complain to that commission too. But I think the Accountability and Transparency Commission, if you see that under Chapter 10, I think, it is, you'll read that it's Chapter 8, sorry, my apologies. If you read subsection 6 of 141, it's completely independent. So anybody abusing powers can, of course, be referred to that commission. In respect of the appointment of judges, I think, if you look at Australia and New Zealand, they have a similar position, where you have the Attorney General and the Prime Minister involved in the appointment of judges. But before they actually appoint, you have the Judicial Services Commission that in fact does the selection, and then they recommend names, and then judges are selected. As far as the Chief Justice is concerned, under the 1997 Constitution, the 1997 Constitution said that the Chief Justice is appointed by His Excellency the President following the recommendation of the Prime Minister, who consults with the Leader of Opposition. So in fact, that is more of a political issue than anything else. We have two opposing camps. In respect of this provision, you have the Prime Minister following consultations with the Attorney General. Whoever the Attorney General is, the Attorney General is supposed to represent the bar or the legal fraternity. So that's why the Prime Minister consults the Attorney General and then makes the recommendation to His Excellency the President. Now, this is not an unusual thing. It happens in Australia and New Zealand. Exactly the same thing happens. But I think what we need to ask is, once a person is appointed, whether as a judge or an electoral commissioner or a commissioner on the Accountability Transparency Commission, governor of the Reserve Bank, whether there is constitutional protection for that person to be independent. And the Constitution, if you look at the various provisions that have been set out in the chapter under the judiciary, it says that anybody appointed to this position is completely independent. Nobody can interfere in the process. And even if you look at some of the other provisions of those people who are appointed to such positions, you will see that it says that you can't even change their salaries or reduce their salaries, I should say. And there is a specific provision that says, for example, if you look at page 76 of the draft relating to public officers, it says, in the performance of his or her duties or functions or exercise of his or her powers, a person to whom this part applies is not subject to the direction or control by any person, except as provided under this Constitution. So I think we need to look at, once a person is appointed, are they under the subject and control of anybody? And the Constitution provides enough protection to say that even if a person is appointed on the recommendation of the Prime Minister, following consultations with anybody else, that person will be completely independent.
Bitagni sa somitigo na wada taru wana wekanda ni taru tiu mayana ngauna boru takina Vakekeli en FBC TV. Dua talemanda na nonda dengu na kale. Oni boru ngatigo mai kina sali ni kakamburagi na radio fijuan do mai bitina bonga ni viene no ngauna boru takina Vakekeli en sarabi talanga na FBC TV. Nonda bulangi tiko na turang na buni lawa ni nonda matintu ka Prime Minister Mr.Aiyaz Saiyed Khaiyum. Dana listo lemanda kina taliboni na kanta toki ngo nimbula kimni.
Nimbula binaka tau.
Nimbula binaka.
Endo sa no kerkere. Ngo soula ni bidini. Na kimami yana ngono ngo sansan ndoni labela bini ya buni ba bole wati ke kimami. Kimami sa tu bo lo asar tu ngango. Yana por karamoni ndombi te tigana na ndomi bite kimami tali ta bolebu. Mero ni kimami bokila kimamu na zabana ka. Itigalo mani buni bole wa kere ndo sagana kere kere to. Kimami kere tian kero ni bakauti maindo mero ni mai forma la wa biti kimami. Bete kimamana kamuni lo mani volokeni tasin o kimi tu sartu ngabelo. Ko sangora kere kere.
No, Bolebu Sola from within the village in Tenancy. He's saying that at the moment they don't have any copy of the draft constitution, and he's asking if there is anyone available from your office who can go up to the village and explain what's in the draft.
Sure. If he can give us his details, contact details, we can make arrangements with him. If he can get his mobile number, you can call him, or phone number.
Saulo ke pakau ni war ngati mai ke war ni uni sulia mataram da mai na nomuni nampa ni telefoni me wasa war tati wan turang ra buni lawa errao ni rutongo le dakani me la kibo madala takina pika itu en labe ni yabu ni wabolwa ke pakau ni war ngati mai saulo kiriti kono nomuni nampa ni telefoni ni sambulo kemni
ni mbolo na taung ko sa nang namba
iya mai saulo
na 84335509
84335509 84335509.
Yeah.
Okay, sabi na walebu saulo, na walebu. That's his number, 8433509, Saula from Naibudini village.
Sure, somebody will definitely get in touch with him.
Ni sana rongo tiga Saula na ndo berto na police station ngai betar tar tiga ni sambula kimning ona Vakekeli.
Iya ni sambula binaka rotualisi. Ando tunga no kutara bona nonda bulani. O bilke so ngi lambasungo. Membele tanga na wasetini ni awone babulo wa baturingo. No kutaro itu na wasetini. Dabona buna mbiuda katale chuma ikina na awone babulo wa baturingo na nonda wosoti nanda woviri. Dabona buna mbiuda chuma ikina na awone babulo wa baturingo na woviri. Wala tanakango na rani bakasudu mutungama na bobiri na baisi ni mataka. Na buno ndo bosudi chuko na zakabutu na tabungu mbata. Sini to bobina ngo e baka mabotaki. Bobota na ndabanua, bobota na ndambula. Yeni to mbodi mko da kala mai capital na wala bakaturi ngo ya da bomata ya da verto bia basudu mutunga na bobiri orto na materi tungo. Kanelewa.
Na kuna wale buna tarumai lamasa. He's asking about Section 10.
Section 10 is about freedom from slavery, servitude, forced labor, and human trafficking.
He's saying about the section that says about people who...
Oh, the immunity.
Immunity.
Oh, Chapter 10.
Chapter 10.
Sorry. Okay. So he's asking why is it there?
Why is it there?
Okay. Thank you for that question. The immunity provision is there. As you know that, for example, we had 2 coups in 1987. So when we explain immunity, we explain there are 2 aspects to immunity. For example, when the soldiers, or whoever it was that walked into Parliament House on 14th of May 1987, the people who physically walked in, with guns and balaclavas. And then you had, later on, Major General Sidiveni Rambuka walk in and they took over Parliament. And you had a coup and they removed Dr. Timothy Bavandra. So that's the actual physical act. And then subsequently, you had new laws that were passed. So you had the Governor General who became Ratu Penanganilau, became the President. So he made a decree saying that I'm the President now and the executive authority will vest in me. He also then made new laws. For example, we had judges who were appointed and various new laws were passed. And you had civil servants who were appointed, ambassadors, numerous other things were done. So those people, including those people who physically took over government, and then those people who later on became, for example, the Governor General became the President, and those people who were appointed under various decrees, it could have been challenged to say that these were all illegal acts because there was no parliament that made the law. But they were given immunity and a total new regime had started. So the 1990 Constitution gave not just the soldiers who walked in, but all those people afterwards, who made laws. For example, Ratu Penanganilau, the ambassadors, the civil servants, the judges, every single person that were appointed and took up positions under the new decrees were all given immunity. So you could not challenge the fact that they had done all of this. That immunity, which is contained in the 1990 Constitution, passed on to the 1997 Constitution. That immunity carried on in the 1997 Constitution. This Chapter 10 also gives them immunity. The draft Constitution says they also have immunity. And then it also gives immunity to those people in the events of 5 December 2006. So, for example, we have had judges who've been appointed under decrees. We've had the interim government that was appointed by the then president, former president. You have the current president, Ratupela Nelatikau, who's signing decrees. Everybody is given immunity from there being prosecution against them. But if you read Section 10 under Section 154, that immunity does not extend to criminal offences from Section 77 to 390 of the Crimes Decree. In other words, if today, so I'm given political immunity from being Attorney General, but if tomorrow I go and rape somebody, if I go and steal and I'm charged for corruption, or I run over somebody, when they're standing on the side of the road in a car, I don't have immunity for that. There's no immunity for any of the crimes committed between Section 77 to 390, which includes those things that I'm talking about. But there's political immunity. So the immunity given for 1987 events and the immunity given for 5 December 06 events are included in this draft constitution.
Mitagin sa matata waisa ke voka ni rongo tati unauni pamadala na turanga punila and nandanganuga. So recently the New Zealand government has just passed a bill on same-sex marriage. What is the stand or are there any provisions in
Sure.
our draft constitution on this?
Sure. This question we get, we explain this quite a lot whenever we go on outreach programs. If you look at, for those of you who may have the Constitution in front of you, if you look at Section 26, 3A, it talks about how we should not unfairly discriminate against people, depending on the ethnicity, the race, the gender, the language, and now we've included culture. We've now also included religion, marital status, and pregnancy. That you can't discriminate unfairly against these people. So, for example, if you apply for a job, if say a female applies for a job, and they're going to give her a job, but then they decide not to give her the job because she's pregnant. So you can't unfairly discriminate against her. Or just because somebody is married, you say, oh no, I'm going to give her the job because, she's married and she may not work hard enough. Or you discriminate against somebody because of their religion. In the same way, you have sexual orientation. Now, what it basically says is those people who are homosexuals, or who may be feminine or whatever, a bit feminine as some people see them as, you cannot discriminate against them. So you can't say, okay, just because they're homosexual, we tell them you go and sit at the back of the bus. You can't give them a job. Or you say you can't go to the restaurant. No homosexuals can go in there. That's what it caters for. But the draft also says that a law of marriage cannot be used by homosexual people to say that we are discriminating against them. Put it the other way, the law of marriage has a superior position in this draft constitution. And the law of marriage in Fiji says that marriage is a union between a man and a woman. It's not a union between a man and a man or a woman and a woman. The law of marriage in Fiji is a union between a man and a woman. So if you look at Section 26, subsection 9, it basically says that the law of marriage prevails over this section. So as I've explained to people, that you can't discriminate against homosexuals under this provision, but it doesn't mean they can get married to each other, because the law of marriage in Fiji is a marriage or union between a man and a woman. The other point that I want to also raise, if I could, is in respect of, we've got freedom of expression and speech. That's in the draft constitution. But there are certain limitations. Just because you and I have got freedom of expression and speech, it doesn't mean that you can go and stand on the street and say anything you like. So you can't say anything that will incite hatred. So, you can't go and stand on the street and say, it's my freedom to say anything, so I'll say, let's go and kill all the Chinese people in Fiji, for example. That's inciting hatred. I had a question that was asked by a Talatala in Nandi, and he said, can I preach in my church from the pulpit to say that homosexuality is wrong, that it's not a moral act in God's eyes, and that, you can go to hell for that? And I said, of course you can, because he's teaching, he's expressing his faith, and that's what he can teach. That's the belief, that homosexuality is not a good thing, in his church. That's his belief, and he can preach that. But if he says, let's go and kill all the homosexuals, or let's go and all beat them up, then it becomes problematic. But there's nothing wrong in teaching about the morality of it in your church.
Kimni na turang kel marama be kimni na vorong ati mai namba ni talewoni na toluroro sai badio nan rau toluroro sai badio sai bandua. Ti una nomni vota tan ro banglo ti mai vona vuni law nanda matintu na prime minister wa tawa. Membele tati ngani labi ni nanda ya vundi wa vulewa. Talam do nanda veng en ngono vorota kina Vakekeli. kona ngauna waro taki na Vakekeli kana dhingomi te kona watataro vangule te watamba indua membala tana ilabe ni avu ni wabulwa ni sambula kimani iyo ni sambula binaka ni sambula iya ni bula
tarongo talenga na aina tarongi manda na kwerna dulu lagi na wavala le songo tu tau tu na lewa mer le songo en pana dona kisia na kani telecom a chemen sini so tau tu bona lewa kwa sini wauti na kani bali besu yo kwa wali le se kwa le ka kana ka ta bena prime minister bade prime minister liu kwa tau tu bona bakit don lewa bula vitu kwa wauti mai bali besu yo na chemen ngo se kwa tau tu ngabolo bakin dua yo serenga kango kailangan kan na muri ke dua tau di lawa tama vai la bo tama tama ngame ko wa wati mena na ketau di bo na lawa me ko balbes me ba wati men bolu ka na korona ka na ito ke lender affairs ko na ka vengra di ngo bagitin ka tolong na tama mai sinin tortuli mai torba ko na ngeler na toke yo na kango isindan ka ka toke fes ke na ubisa bin kan ke muri dona lista ke men dokai chiko na tamata listi ko na listi ko na bina ko baleu
una vole na taro mai be Mr. Singo kla mai raya en puni ke wara ni nge pa mata talam da mai na numni taro oni taro ngoti mai and maybe would you like to reiterate what you have just said earlier? I think Mr. Singh from Ra was asking something about this Itauke land, the one that you were saying that people cannot be chased away from the land. He was asking about it.
But Itauke ownership?
Yeah, ownership.
Yeah, of course, they can't be removed from the land. There's complete protection for that. Even the laws as it stands, the Native Lands Act says you cannot take away the land. I don't know whether he's talking about that or was he talking about tenants?
Yeah, tenants.
Yeah. Tenants. No, in respect of the tenants, of course, there are certain laws that govern that. For example, the Agricultural Landlords and Tenants Act. So as we highlighted in the program last week, that not a single tenant has been removed outside the ambit of the law. Of course, I mean, as we've explained to people in Lambasa, if you are leasing Itauke land, and the lease is expired, it's the landowner's choice whether they want to renew it or not. It's their choice. You can't force anybody. In the same way, if you have a shop and you lease it out to a tenant, when the lease expires, it's up to you whether you want the tenant or not. So I think, it was very interesting in Lambasa because a lot of leases, for example, in Lambasa weren't renewed, because of sort of politicians and politics. But some of the landowners now want it renewed because many of the areas where the leases weren't renewed, there's nobody farming now, the shops have closed down, etc. But the choice at the end of the day is up to the landowner. But those people who are already tenants, their rights are protected through the actual lease agreement that's in place.
Ni sambula kimni?
Mula.
Ni bola binaka?
Polis. Ndo sangana taro. Go o pesa nereve. Beletu rena wakan remati simala itu na longo senga is unda klan na vi taun di lewu na santunga na bono erlembul kina na wakan remati ya na taro chuko o bimbe kama na vi korkoro viti se vi korkoro itu ki ya madalanga na bono erndo umbulu tukina na yang mati o vi kindue de voi la bonga se la otale krebo bon mo be ala sambulunga na ngoni mate seno na vale dunia na ina romani korndun sa do ti ona ngono tumbe na ya buni bo bulewa ya se mikmem bo klat mo na ngoni meni be sevi.
Yes, he's asking about this question, where people are buried. Is that up to their relatives to where they want to bury them, or is there anything it says in the law that they should be taken to the special place like the cemeteries?
The reason why they are designated cemeteries is because for health reasons, etc. Of course, but as you know that in Fiji there is also a practice where people, for example, bury their loved ones in the villages.
Yeah.
There's certain burial areas that have been identified. So I don't know whether I'm answering the question. So I think that's still allowed. But the reason why there is you simply just can't go and bury somebody by the roadside because there are obviously health issues, etc. And if it's not done properly, it can be a health risk. But if you, for example, some people we've seen in the past who have just buried somebody by the side of the road. If, for example, there's going to be an extension of the road, you want to create 2 lanes, then you have to exhume the body, and there's all those sorts of issues. I hope I'm answering the question.
Nisambula kimni ngono Vakekeli?
Nimbula vinaka.
Nimbula
Roto alesi. Osaki usangango iraki. Vetar tunga buana nanda bunilawa. Nangai bakala buana norto wa bukitingor na baka sa community ko tigo na bunya bri bobulawa. Roto nambo mai warungo di kama mitalanga na to ningo iraki. Sena sanangora ser tu na takosonga mengor bono le berto sala ko na sa sabara to sabara ila talan di kanda pungor. Ukaranga karan dono rego madala to no bodo mai bango men blitz ke mamna le bono ngoira sena.
He's calling from Rakiraki. He's asking, will the team go to Ra?
We hope to. In fact, we'll be in Tavua on Thursday night, and we're trying to fit in as many places as possible. There are a lot of people who are ringing up, but we hope to fit in Ra maybe the following Monday.
Okay.
But we hope to do that. Yes.
Sa kiusa sa sumitigo ano numni bota taru ertuna sanga mertuna adani. Evana numni tukutuku.
And we'll give the notice out on the radio.
Anang kami kadi bagitalhan na kene tukutuku. Do mandanon da vengu en ngauna waru taki na Vakekeli en single. Toluro sai vadio nan rau toluro sai vadio sai bandua na bitu toluro dio nan rau ke na bitu toluro dio sai bandua. Nomuni taro liuma ni adamuni kina buno ningiri chuma kina abangalo chu wana nonda buni launi matin tu ni sambula kema
api bulat na kapi ayo balwan sing talengo aiji my question was that I got originally from 1999 and it's taken away since 13 years, but now reaction from the TLTB and the government. We have seen everybody, but now reaction. I have paid last 6 years the rent, but now I can't pay the rent because I'm not using the land. Before I was producing more than 500 ton cane, but now it is overgrown bush and African tulips. Thank you.
We can, take his phone number, and we can get in touch with him directly to see, specifically what his problems are with the lease, etc. Then we can help him.
His number is 755-2490. 755-2490.
Okay. We'll have somebody call him up and find out his specific details.
Bulavina Karatuali. Bulavina Kaya, Senegal. I'd like to raise a question in regard to Christian access. You have explained already the immunity. Is there any provision for such an act in future? Yes.
Okay. No, in fact, there is no provision in the draft constitution that says that there's provision for further immunity. What it does say, though, if you look at Section 2, subsection 4, it says, any attempt to establish a government other than in compliance with this constitution shall be unlawful. In other words, if anybody else tries to, after this constitution comes into force, tries to establish a government that is not based on this constitution or in accordance with this constitution, then that shall be unlawful. So in other words, you can't get immunity under any act that tries to establish another government other than you being voted in to government. And the other point also just to make is that under this constitution, the term of government has been reduced from 5 years to 4 years. So people can vote more quickly compared to what they did before. So people have a quicker say in electing and changing governments. So all of these things combined, is to attempt to stop what we call the coup culture in Fiji.
Mitak ni sa di komiti ko na itutuka. Ni sa ambulo kimni ngona Vakekeli.
Ni sa ambulo minaka. Indo kana pakataro ngol chungani ngo rtupeni lambasa. Pati kana constitution ka bu kol kuchungo ndo kana kani ndo kana metero ngurtu nele ba kitu taronga ni de duru chugana constitution ngo mbala tsona company ni security ya sana ngo ibonole go. Sona company security ngo $1 tungandona $1.10 ko mbo le usara $1 basangu rani pamata tamanda mayo nuntu ulang si ta mandana la read dina ni kon ni security chuko mana constitution bongo
what's
na wale
Peni ke wani voronti mai. Sa ni bitel mandai. Kere moni ngai is talking about some security companies there in Funole.
not paying enough wages?
Yeah.
In fact, if I could just highlight that also, yes. Very quickly, the minimum wage for security officers about 3 years ago was about 90 cents. Now it's gone up to about $1.40 or so. But obviously there's a need to increase that more. But under the draft constitution, to bring it back to the draft constitution, under the socio-economic rights, it says that the state must take, or the government, whoever is the government, must take reasonable steps to ensure there is a just minimum wage. In other words, we must have minimum wages in Fiji, which is fair. So if you look at the socio-economic rights included in this draft constitution, there's a lot of things that have been put in there to ensure that all governments, irrespective of whichever political party it is, they do the right thing in terms of socio-economic rights. We have a right to housing, sanitation, reasonable access to transportation, economic participation, right to health, social security schemes, right to adequate food and water. All of these things have been put in to ensure that no matter which political party comes in, they will spend their money on these areas that is of concern to people. Again, it goes to the, about the coup culture. Because some people would argue that many people, for example, who came down in 2000 after Chaudhry's government was, held hostage, etc., and people went down to Parliament House, many of these people were poor people who were told, they don't have basic housing, they didn't have access to water, roads, good roads, etc. So they said, look, come and support this and then you'll have all these things. But of course they didn't get it. But the point is that if all the government works towards these people getting these basic things, then we can stop political upheavals also.
So the division of seats, yes. The draft constitution has any provision of?
Yes. If you see, those of you who may have the draft constitution, if you see at the back, we are using the existing divisional boundaries. So Fiji is divided into the Western, Central, Northern and Eastern division. And each of these divisions get a specific number of seats. So the Central division, people who live in the Central division, they will choose 18 people. Western division will choose 16, Northern division will choose 7, and Eastern division will choose 4. Now we've used Yashgai's permutation for this. So these number of seats have been allocated on the basis that this is the proportion of the population that lives in these divisions. So if, for example, there's later on any change of population, say from the Western division to the Northern division, the Independent Electoral Commission will divide the seats accordingly. But at the moment, these are the seats that have been allocated. And it's what you call multi-member constituency. In other words, when you go to vote, if you live in the Northern division, you have to tick for 7 names, 7 people you want to represent. Under the Yashgai's policy, the recommendation was that you choose the political party. So you give 1 tick to the political party. They will decide which 7 will go in or which 4 will go in. Under what is being proposed in this draft, when you go to vote, you choose the 7 people yourself. Because you may, for example, choose 4 from one political party and 3 from another. It gives you more of a choice. So that's the basis on which you have the electoral divisions. And you have 45 seats. So altogether from Fiji, you have 45 seats, and they're broken down according to those divisions.
Ia na po madal tiku me balatan vi kai tu en ilavi ni avuni va kulewa na mali telefoni na tolu ruro sai va dio nan rau tolu ruro sai va dio sai bandu ia sa tombo ki roti ona ngauna ka po binu na ta ki bikim ni na vorngoti mai en ka veni dai nui ta taltiko ni oni na la ko ti o le buna be buno eso en la ko ti ni kina na no mata ti na turana buni lawa na toni general tono ma bo ti ni na be buno eso. So time as where the program comes to an end, would you like to just tell the listeners out there other places that you will be, so that
Yes, sure.
they can come prepared.
Tomorrow evening we'll be in Nasinu. So there's a school hall at Rishikul School. So please, those people who live in that area, please attend. And don't feel that you can't ask any question. You can ask any question. No question is too small or too big. And this is an opportunity for you to ask, seek clarification on anything. On Wednesday, we're going to Kandavu. On Thursday night, we'll be in Tavua. Tavua and his people have asked for us to be there. And we're inviting everybody who lives in that area to attend that too. On Saturday, we will be on Naviti Island in the Yasawas. And we hope to be on Monday, in Raki Raki. And we'll give that, the details for that. There's a couple other places. We've got some invitations from, for example, one of the disabled associations. They want us to come and speak to them, and we'll be going there. Because as you would know, in this constitution, the draft, we have a provision for disabled persons too, for the first time. They've been specifically given rights.
Kanda pabili na tiku wana turana vuni laun nonda matintu na Prime Minister Watawa and nonda mai nonda bulang tiku na ngauna boro taki na Vakekeli and na. We'll just take the last call for this program. Ni sambula kimni?
Hello.
Nimbula binaka?
Nimbula binaka. Nimbula.
Yo nimbula nomini taru?
Yeah. Au ngomulu tanga bana turango rio Mr. Khaiyum. Yeah. Mr. Khaiyum.
Yes.
We just got 2 areas of concern. First is about our land. You have stated sometime last week,
sure,
this in relation to Section 5 of the Land Act about the MOMI. So, any government of the day who issued power cannot do or redo what Raisen Yangarase has done. Number 2, this in relation to the candidate for election. I think it's a bit unfair for people who have been to jail to come back and not to be re-elected in Parliament because they have this rehabilitation process which title Yellow Ribbon. Give them the second chance. So this is Mbunembune from Nakachi. Thank you.
Okay, no, thank you. I'll take the second question first. Very quickly, at the moment, what the caller is referring to was the draft says that if you have been sent to prison for a sexual offense or corruption or abuse of office, then you cannot stand for Parliament at least for 5 years until after you've been released. So, if, for example, if I've just come out of prison for, say, raping somebody, I've been sentenced to prison, I come out, I cannot stand for elections until 2018, so 5 years from now. So there's like a cool-off period. Some people have said that you should make it 10 years. Some people have said you should have a completely, clean track record. What if you've been sent to prison for, careless driving or dangerous driving? Should you qualify or not? And we, urge for people's submission on that. And that is his submission regarding that. As we've seen that some people, for example, previously have been to prison and immediately have become vice president or held some other position. Some people said, if you hold public office, you need to have at least a period of time in which you have not done anything wrong. And that's how some countries treat it, and that's the provision here. But of course, we're open to various submissions that can be made on that. In respect of the question about whether what the Ngarase government did in 2006, whether it can be repeated or not. Under this draft, no, it cannot be repeated because you've got the protection under the Bill of Rights. Because every executive decision, not just a law, but any executive decision or administrative decision is subject to the Bill of Rights. So if the Bill of Rights gives you protection in regarding land, then you can't even make that step to try and make that decision. So that is the protection that we have. But obviously, in this particular instance, what happened in 2006 was a blatant disregard for Section 5 of the Land Transfer Act. Oh, sorry, Native Lands Act. Sorry, I should say.
Da pabili na wale wana nonda bulangi na turana punila nonda matintu Prime Minister Watawa nonda mai bulangi tiko na cabinet sana mai dawo sa talaki na ngona boru tekno. So thank you very much for your attendance today.
Thank you for having us. Thank you.